This show provides a brief overview of the Sixth Amendment's Confrontation Clause as applied to hearsay statements. If you have not already read the assignment, please do so before watching the video. Let's start by looking at the text of the Sixth Amendment's Confrontation Clause. It says, "In all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him." There are four key words in this provision: criminal, accused, confronted, and witnesses. Let's look at what each of these key words means. First, criminal tells us that the clause and its protections apply only in criminal cases. Accused tells us that the clause protects only the defendant, so you only need to worry about the Confrontation Clause when the evidence is introduced against a criminal defendant. It does not limit evidence that a defendant advances against the prosecutor. The word confronted has been interpreted by the Supreme Court to mean ability to cross-examine witnesses. So the right of confrontation is the right to cross-examine. When a witness is testifying in court, there generally is no problem. But not all witnesses testify in court. When does a witness not testify in court? When her hearsay statement is being offered as evidence. So let's look at the fourth key term, witnesses. Hearsay declarants are treated as witnesses. The idea is that if a person's out-of-court statement is offered in court, that person is, in essence, a witness in the case. This is how hearsay and the Confrontation Clause are linked. Not all hearsay, however, implicates the Confrontation Clause. In the Crawford case, the court told us that the Confrontation Clause only applies to testimonial statements. In other words, a hearsay declarant is only a witness if her out-of-court statement is testimonial in nature. So, for purposes of the clause, the term witnesses means people who give testimonial evidence. Whether the clause applies to a hearsay statement, therefore turns on whether the statement was testimonial. The court has been trying to clarify when statements are and are not testimonial in several recent cases, and we will spend most of our time in class on this issue. So here is how the court has interpreted the Sixth Amendment. Confrontation changes to cross-examine, and witnesses changes to people who make testimonial statements against the defendant. As a practical matter, the clause thus reads, "In all criminal prosecutions, the accused shall enjoy the right to cross-examine the people who make testimonial statements against him." There are 6 basic principles that inform any Sixth Amendment examination of hearsay. First, the Confrontation Clause only reaches statements that are offered for the truth of the matter asserted, that is, hearsay statements. Second, all evidence must satisfy the rules of evidence. Check that first. In particular, you must find a hearsay exception for the hearsay statement. Many hearsay statements are excluded because no exception applies, regardless of whether the Confrontation Clause would bar the evidence. Third, the Confrontation Clause applies only to evidence offered against the accused, that is, the criminal defendant. If it's not a criminal case, or if the defendant offers the statement against the prosecutor, there's no Confrontation Clause problem. Fourth, the Confrontation Clause only applies to testimonial evidence. Therefore, if a statement is not testimonial, it satisfies the Confrontation Clause. In other words, the Confrontation Clause does not bar non-testimonial statements. Fifth, if a statement is testimonial, the Confrontation Clause does apply, and the accused must have a chance to confront, that is, to cross-examine, the person who made that statement. Again, This distinction between statements that are and are not testimonial is critical. And finally, if there is no opportunity to cross-examine that person at trial, the prosecutor may only use a testimonial hearsay statement if the prosecution establishes both that the declarant is unavailable and the defendant had an opportunity to cross-examine the declarant at a prior proceeding. This is a difficult standard to meet. The court has also recognized two exceptions to the Confrontation Clause. The first is for forfeiture by wrongdoing. This works just like the hearsay exception. It applies where the defendant purposely made the declarant unavailable in order to prevent the declarant from testifying. Some states have a broader hearsay exception for forfeiture, allowing the declarant's statements to be admitted if the defendant made the declarant unavailable for any reason. But the Confrontation Clause is limited to witness tampering and therefore serves as a check on these states. The second exception is for dying declarations. In multiple opinions, but only in dicta, the court has noted and seemingly endorsed a special historical exception for dying declarations. This means that if the prosecution can meet the requirements of the dying declarations exception, the statement is admissible regardless of the Confrontation Clause. Let's see where we are. You need to consider the Confrontation Clause if the prosecution is offering a hearsay statement against the defendant in a criminal case. When you have a confrontation issue, there are four alternative ways to satisfy the Confrontation Clause. The prosecution only needs to find one that will work. Okay, so the prosecution can show that the statement was not testimonial. The key issue here again is which statements are testimonial. We're going to work on this in class, and I've also included a rough guide on the next slide. The second way for the prosecutor to satisfy the Confrontation Clause is to show that the defendant had a chance to cross-examine the declarant at the current trial. In class, we'll look at when a declarant is available for cross. The third way that the prosecutor can satisfy the Confrontation Clause is to show that the declarant is unavailable and the declarant had a prior opportunity to cross. In class, we'll look at what constitutes a prior opportunity to cross. And fourth, the prosecutor can satisfy the Confrontation Clause by showing that the statement fits a Confrontation Clause exception. And we've seen that there are two, for forfeiture by wrongdoing or for dying declarations. Determining whether a statement is testimonial is critical under the new framework because the clause only comes into play if the declarant made a testimonial statement. Over the last few years, the Supreme Court has focused closely on the issue of when a hearsay statement is testimonial. In class, we're going to look at the major cases and work on drawing the lines. But here is a rough guide to get you started. The court has said that statements qualify as testimonial if they are made at proceedings such as a grand jury hearing, a preliminary hearing, or a former trial. A statement will also count as testimonial if it was made during structured police interrogations, typically at the station house. Statements are also testimonial when made during informal police questioning, as long as the primary purpose was to prove past events with a view to later prosecution. Also, the court has said that formal lab reports are testimonial in nature, and that would include lab reports on things ranging from whether substances are drugs, the blood alcohol level in the defendant's system, fingerprints, and similar. The court has also made clear that many types of statements are not testimonial in nature. Typically, statements are not testimonial when made to private parties, such as a friend, neighbor, or a business person. Also, statements are not testimonial when made to police, as long as they were made during an ongoing emergency in an attempt to help the police resolve the situation. Again, we'll look more closely at this in class, but before we finish, let's look at an overview of the steps of analysis when you're dealing with a confrontation clause issue. Okay, first, you'll need to look at whether the statement is hearsay. If it is, you need to determine whether it meets a hearsay exception. If it doesn't qualify for an exception, then it is inadmissible and you're done. But if it does meet an exception, then ask whether it is offered against the criminal defendant. If it is, then you need to deal with the confrontation clause. So your next step is to determine whether it satisfies the confrontation clause. There are 4 ways to do this, and you only need one that works. Here are the options. First, you can show that the hearsay statement was not testimonial. Or, second, you could show that the defendant had a chance to cross-examine the declarant at the current trial. Third, you could try to show that the declarant is unavailable and the defendant had a prior opportunity to cross-examine her. Or fourth, you can try to show that one of the exceptions applies because there was forfeiture by wrongdoing or the statement was a dying declaration. That's the overview. Please take the short quiz on TWEN, and I'll see you in class.